Are you making sense to your examiner? Chances are far from it. Hi, and welcome to the Law Simplified, the world's largest independent online law school platform. I'm your instructor, Shaveen Bandardanayake. Having conducted fast-track and masterclass programs on a one-on-one basis for students from all around the world, and the Law Simplified now amassing over 60,000 alumni from 191 countries, one clear distinction between average students, good students, and great students is encapsulated in one phrase: clarity of thought. What do I mean by this? Over the past nearly 10 years of tutoring students from all around the world, I've honed my technique of providing feedback reports in terms of assessments, mock examinations, and even assignment submissions that students tend to advance or forward to me to go through and provide detailed feedback on. And what I've gathered over the years, and this too having spoken to examiners from different universities over time, is that the actual difference between a student that passes an examination, perhaps gets a second lower, a second upper, or the elusive first classes, is really in how they have communicated or articulated their ideas to the examiner. If you like the type of content that I make on this YouTube channel, do subscribe to the Law Simplified and leave a comment below of what other types of videos you'd like to see to improve your academics and professional prospects in law. I'd highly recommend having a look at the comprehensive online law school platform, complete with theory, tutorial, and workshop lessons based on the actual one-on-ones that I've conducted with first-class law students from around the world. Now, it's easy for me at this stage, having gone through around 34 different modules from 3 jurisdictions, answered student questions, and honed my own technique to tell you to have clarity of thought. It's very abstract in terms of the idea. It's subjective for a person who's just hearing it. So the best way to go about this is to show you an example of the difference that clarity of thought and how articulation plays a critical role in helping you not just pass an examination but ace it altogether. So let's have a look with a very simple example based on an extract from an examination question in property law. Let's have a look at this scenario based on adverse possession in land law or property law. For those of you who may not be familiar with the particulars of adverse possession, I'd highly recommend having a look at the comprehensive online law school platform, which is complete with theory, tutorial, and workshop lessons, and it'll guide you from A to Z on not just passing but acing the examination altogether. But for the purposes of this particular question, I'll guide you through a little bit of theory that's relevant to this scenario. But before we proceed on to considering the arguments and how you can implement the principles of clarity of thought and articulate ideas for your examiner, let's first give a few minutes, or you can pause this video if you'd like, and read the scenario in question. Mind you, I've stripped away elements of this question that relate to other arguments as well, and will focus entirely on this one point that I want to impress upon you or advance. Okay, so I hope you've had an opportunity to go through this scenario, and for those of you who are familiar with adverse possession, it should essentially ignite, or it should be a catalyst for a few different ideas and arguments already. But what I want to focus on predominantly is the fact that this relates to a squatter's rights, considering the circumstances which are present, indicating that perhaps Sarah and Molly do have factual possession with an intention to possess. Now, to outline very briefly how adverse possession under registered land operates, it's basically when the squatter, the person who's on the property and potentially has possession, indicates, or by virtue of certain factors on the property, shows that they have factual possession with an intention to possess without the permission of the paper title owner for a period of 10 years. At that point, the squatter is capable of applying to the land registry to register themselves as the paper title owner. Previously, this law was slightly different, wherein you're not able to essentially apply to the land registry, but rather on the completion of 12 years, it either happens automatically when it comes to unregistered land, or in terms of the old registered land rules, the paper title owner will become a trustee in terms of the legal title holder, and the squatter becomes a beneficiary, and the legal title holder, essentially the paper title owner, is supposed to transfer the land or the property in the name of the squatter. So this essentially adds insult to injury. This is according to section 75(1) of the Land Registration Act of 1925, the previous piece of legislation. Okay, now what's important to us in this scenario, and what I want to impress upon you as to why this is relevant, is that the key or the fundamental issue here relates to whether at any point the paper title owner, the European Nuclear Fuels Agency, the ENF, has essentially given permission, either implicitly or expressly, for Sarah and Molly to do what they've done. The objective here, or rather the effect of this, the consequence of such permission being present, is that they will not be able to fulfill the requirements of adverse possession for a period of 10 years. Essentially, the clock stops. Now, I've highlighted two elements or two factors within this scenario that are relevant to this argument. So, on the one hand, it says that Sarah and Molly are the owners of a small cottage and garden. So, that is what is adjacent to this property, which they had bought in 1990. And at the very end, it says, after having seen what Sarah and Molly have done to relatively improve the property that is owned by ENF, the wasteland, they essentially released a press statement welcoming this fact and the fact that, sporting facilities and the local community benefiting out of it. Now, on the one hand, the question is whether this suggests, implicitly at least, that Sarah and Molly have been granted permission and thereby a personal license to be on this property. The effect of this is that Sarah and Molly will essentially not be able to, at any stage, claim this property as their own under adverse possession principles or rules. Now, most students will look at this and argue on that front, which is completely fine, and you are capable of doing that and achieving a relatively respectable grade. But what a student, perhaps at a higher echelon of a second upper, or most definitely a first class level, how they will advance an idea and how they will frame this as an issue, indicating to the examiner that they have clarity of thought and giving an opportunity to the examiner to really give the maximum potential grade or marks possible, is to assess whether this press statement happened before or after the completion of the requisite 10-year period, or even in the case of the old registered land rules, 12-year period. Because quite notably, at least in this scenario, apart from the year 1990, which is indicated definitively to be the date that Sarah and Molly came onto the adjacent property, there is no mention of when, if at all, this press statement was given, or released rather, and whether that was in 2000, whether that was in 2020, 2023. Since we don't have an idea of this, it's not possible to definitively state whether Sarah and Molly has lost that third common law requirement, the absence of permission. So even if this release, the press statement being released, amounts to implicit permission, the lack of when it was released means that it's difficult to establish whether Sarah and Molly have lost their rights as a squatter. Now, this framing of an issue is something that most students may not do because they will look at what has been presented to them in the question rather than what has not been presented to them in the question. Which is why quite often on this platform and the different platforms that the Law Simplified is disseminated on, I often tell students, both my fast track and masterclass students, that it's not just about what is being told to you, but what is not being told to you. So things in a question are there for a reason. Things which are not there for a reason. So the next time you look at a scenario, be mindful of not just what is superficially shown, but think deeper at the consequences and then establish the proper framing so that you can indicate to the examiner that you yourself have clarity of thought. Right. This was meant to give you a very brief overview and an understanding of how you can leverage facts and frame your arguments in such a manner to indicate to the examiner that you're someone who is analyzing the situation beyond simply looking at the superficial facts that have been given to you. More often than not, when students are presented with questions, they tend to have a very cookie cutter like approach of looking at the circumstances, simply narrating or repeating the facts, along with plastering of the law here and there, and hoping that an examiner will stitch things together. But the whole premise of a law degree, of a qualification in law, is to be able to understand what's been presented to you and find a solution for a client or a group of clients that is before you. So, in summary, when you articulate your next answer, irrespective of the subject area, make sure that you have clarity of thought. If you yourself are not sure about the path that you're taking in terms of the question, neither would your examiner. You are the only person in that situation that's capable of giving an opportunity to the examiner to not just pass you, but give you the second upper or the first class that you richly deserve. That being said, until the next time that we speak, have fun, stay safe, and as always, obey the law.